everyone, welcome back to the channel. My name is Varun Kaushal and I'm a legal intern at LEXIS and Company. Today we are going to discuss about the topic, the right to be forgotten. The right to be forgotten was recently recognized by the Delhi High Court, which ordered Google and Indian Qanun to remove a judgment. But what precisely does this right entail, and how does it relate to the right to privacy? In general terms, the right to be forgotten refers to the ability to have some publicly available personal information about an individual erased from the internet, search engines, databases, websites, or any other public platform. The right to be forgotten has been recognized by the law in the European under the General Data Protection Regulation of GDPR and has been affirmed by many courts in the United Kingdom and Europe. However, there is no similar law in India. Although the Personal Data Protection Bill 2019 tabled in the Indian Parliament by the Ministry of Electronics and Information Technology, which is currently being scrutinized by a joint parliament committee in collaboration with experts and stakeholders, did clearly include and give the right to be forgotten in its clause 20, which allowed an individual to restrict or prevent the further dissemination of their personal data if that data a has served the purpose for which it was collected or is no longer necessary for the purpose, was made with the consent of the data principle under section 11 and such consent has since been withdrawn, and C was made contrary to the provisions of this act or any other law for the time being in force. However, the bill has not yet become law, but it is not as if the right is not recognized in India, since there is where the courts come in. The Supreme Court recognized the right to privacy in Justice K.S. Puttaswamy versus Union of India in August 2017, where it ruled that right to privacy is an intrinsic part of the right to life and personal liberty under Article 21 of the Constitution. And this is what the right to be forgotten has been linked to since then and in this judgment. The Honorable Supreme Court specifically observed that the right of an individual to exercise control over his personal data and to be able to control his or her own life also encompasses his right to control his existence on the internet. This occurred in August 2017, but a few months beforehand, two additional high courts and the opportunity to consider this right, and each adopted two distinct paths. The Gujarat High Court in Dharamraj Bhanushankar Dev versus State of Gujarat decided on a petition brought by one Dharamraj Bhanushankar Dev was previously acquitted in a kidnapping and murder case by the same court and requested that the judgment not be publicly available. The Gujarat High Court refused to grant him relief, noting that the petitioner had not been able to point out any specific provision of law that had been violated, plus the petitioner hasn't really relied on the term and the phrase right to be forgotten as such, but the Karnataka High Court in Sri Vasunathan versus the Registrar General took a quite different approach and recognized the right to be forgotten specifically and ruled that in some sensitive cases involving women in general and highly sensitive cases involving rape or affecting the modesty and reputation of the person concerned, it is said that this was being done in line with the trend in the Western countries. However, after the right to privacy judgment in August 2017, the high courts have adopted a broader perspective of the matter, explicitly recognizing the right to be forgotten and the right to be left alone. The Delhi High Court ruled that the right to be forgotten and the right to be left alone are two fundamental facets of the right to privacy, which has been declared an integral element of Article 21 of the Indian Constitution. The Orissa High Court in Google versus State of Odisha also examined the right to be forgotten as a remedy for victims of sexually graphic images or films frequently shared on social media platforms by porn lovers to frighten and harass women, lamenting the lack of a mechanism to permanently wipe material from the internet in order to protect the right to be forgotten, called for a debate on the issue and said that information in the public domain is like toothpaste. Once it's out of the tube, you can get it back in, and once it's in the public domain, it will never go away. The Kerala High Court, as well, recently granted the petitioner's request to have his or her personal information removed from a Google search result. The Delhi High Court's latest judicial order that acknowledged the right to be forgotten, the court was considering a plea made by one Zorawar Singh Mundi, an American citizen by birth but of Indian descent, who was charged in a narcotics case in 2009 while visiting India but was cleared by both the trial and the Delhi High Court. Mundi later returned to United States and studied law and thereby informed the Delhi High Court that every time a potential employer ran a background check on him using Google, it led them to his judgment, which he blames for his lack of employment thus far. As a result, he requested that three websites, Google, Indian Qanun and VLEX, remove the judgments. VLEX pulled it down. While the case is in court file, the Delhi High Court noted the irreparable harm that it may have done to Mundi's social life and career prospects, even though he was ultimately acquitted and gave him interim protection. The judgment was ordered to be removed from Google search results, and Indian Qanun was ordered to block the judgment from being accessed through using search engines such as Google and Yahoo. Now, the real question is a right to be forgotten an absolute right? In the sense that not every request for removal will be granted, the right to be forgotten is not an absolute right. The Supreme Court did provide some clarity on this by saying that the acceptance of this right does not mean that all aspects of earlier existence are to be obliterated, as some may have a social ramification. It basically said that it could not be deleted when the data is required for exercising the right to freedom of speech and expression and information, if it is necessary for compliance with legal obligations, if it is necessary for performance of a task carried out in public interest or public health, if it is necessary for archiving purposes in public interest, if it is necessary for scientific or historical research purpose or statistical purpose, if it is necessary for the establishment, exercise or legal claims. Another thing that the Delhi High Court also pointed out about absoluteness of the right to be forgotten in the Mundi's judicial order is that where a court is demanded to be taken down, the court must consider the petitioner's right to privacy on the one hand, as well as the public's right to information, openness and judicial records on the other. As can be seen, India's jurisprudence on the right to be forgotten is still in its infancy, so we will have to wait and watch how it evolves over time. That's it for today's video. Thank you for watching. If you guys have any questions, please do ask in the comment section, and don't forget to like, share and subscribe our channel LEXCLIQ.